those of you who are sitting here in the room and took the time and trouble to drive down here. Our offices are in North Avenue. I drove down Peachtree Street where there was a bit of a demonstration with a bunch of people and police. I thought this was probably not the best way to come to the presentation, but nonetheless, we made it. And thank you very much for coming in person. For those online, thank you for taking 2 hours out of your day for the Ethics and Professionalism Seminar. We do this pretty much annually. Judge Boudreau is gracious enough to participate. My name's David Golden. I'm a partner at Troutman Pepper. The reason I'm doing this is 25 years ago, a lawyer at our firm named Jim Fleming prepared an outline on ethical considerations in tax practice. Soon thereafter, Jim retired and someone had to give the darn seminar, and I did it. And I'm still doing it 25 years later, which I'm not sure what that says. And the only reason I think that I'm doing it is that I think our firm is the only one that has any sort of an outline for ethics and professionalism. So why not just use it every year? We try to make it a little bit different each year. I've tried this year. It's not easy with ethics. So some of this is a bit repetitious. I apologize, but we give it our best shot. I'm going to talk briefly about professionalism because we're supposed to talk about the lawyer's creed in order to get an hour of professionalism credit. So we shall do that. I want to spend most of the time on the employee retention credit and some ethical considerations with respect to it, which are very interesting to me. Talk a little bit about Circular 230. The ethics update is really just a case that was dismissed in the Supreme Court in January involving attorney-client privilege in the context of taxes, which I thought was pretty interesting. And if we have time, we can talk about easements and microcaptives. I'll do an hour, then the judge will give us an hour of a stirring professionalism speech. It will be stirring, correct? Yes, I'm sure it will be. It always is. Here's the lawyer's creed. I worked with the IRS for a long, long time, worked with lawyers in the IRS for a long, long time. By and large, I have found counsel at the government to be pretty good to work with, pretty ethical. I do a lot of estate and gift tax and estate and gift tax audits, work with a lot of estate and gift tax auditors who are attorneys, and I just haven't had a big issue with IRS lawyers. Maybe I'm the exception. I don't know. Other people may have different experience, but by and large, now, agents is a different story, but with the lawyers, I've had a pretty good experience. So we have a new commissioner. Well, he's acting commissioner. He'll be commissioner soon. Danny Werfel. He's the first Heisman Trophy winner to become IRS commissioner. That is, of course, a big fat lie. I have no idea what Danny Werfel, the Heisman Trophy winner from Florida, is doing, but he is not the IRS commissioner. Although it would be something if a Heisman Trophy winner did become IRS commissioner. I just thought it was kind of. Yeah, I thought, hell, maybe the guy, but no, it's not. He's they're here. Pardon? Does he really? Huh? What does he do?
He runs a charity.
Really? Well, good for him. In any event, he is not the IRS commissioner. This Danny Werfel from Boston Consulting Group is the commissioner. He was the commissioner. I don't know if y'all remember, back in 2013, 2012, there was a big controversy with the IRS where conservative groups were fussing that they were not being accorded their rights. They were filing for tax exempt status and they weren't getting tax exempt status. And Lois Lerner was the head of exempt organizations at the time. It was big news. And about that time, I filed a 1023, an application for tax exempt status for an entity called Freedom Wall Foundation. And I do work, pro bono work for the Georgia National Guard. And this foundation was designed to raise money to build a wall out by Dobbins Air Force Base where the Georgia National Guard is headquartered to honor Georgia National Guardsmen who were killed in action. And I thought, well, this will be the easiest thing I've ever done, right? How can it, you're honoring fallen heroes, all that kind of stuff. So we submit the application and nothing happens. Year goes by, nothing happens. And I'm like, what's going on? And nothing happens. We try to get, at the time, Congressman Johnny Isakson to figure out what's happening. He couldn't figure it out. I mean, it's the most non-controversial thing in the world. And the guard was thinking, what kind of a lawyer are you? I mean, you can't even. And it turned out, and I think I got caught up in this, although I'll never be able to prove it, that because the organization had the name Freedom in its title, it was flagged. And that they flagged organizations that had, in their view, kind of provocative political titles for I guess, just because maybe they wouldn't qualify, whatever. But I'm pretty sure that that application was flagged because we used the word freedom, because substantively it was the most plain vanilla application. In any event, he was commissioner during all that going on. Not to suggest he was a part of any of that. The IRS recovered. It's obviously an interesting time at the IRS. He was, I think the Senate Finance Committee on a bipartisan vote confirmed him, so he likely will be confirmed by the entire Senate. It's an interesting time at the IRS. They're getting $80 billion over the next 10 years and how they spend it. And I was on IRSAC and the Internal Revenue Service Advisory Committee, which if any of you at all are interested in doing, I encourage you to do. It's very worthwhile. It's about 30, 40 people. You meet in the IRS building. The IRS pays your expenses. You just fill out an application, and you meet with the top branches of the IRS, the top personnel, and it's kind of a peek behind the curtain, and it's well worth it. But when I was on IRSAC 10 years ago, the concern was the IRS did not have the necessary budget. That you could demonstrate then, I'm sure you could now, that for each dollar you give the government, the IRS, you get $3 or $4 in tax revenue, particularly that dollar is for enforcement. So it was a good investment. As y'all know, customer service is awful. Trying to get in touch with a human is difficult. My understanding is, I've not done this, I've heard this, so that there are businesses that you can pay that will call the IRS and stay on hold. And then when they're getting, I don't know how they do it, but I guess when they get picked or they finally answer, they flip it over to you so you don't have to wait for 2 hours. I mean, I've had situations a couple of years ago, you wait like 2.5 hours and they hang up. It's like, not good. So they really need to modernize, and then they need the money. There was a lot of political flack. I remember the senator from Iowa was concerned that they were going to use the money to buy AR-15s and show up on small business doors, which I don't believe will be the case. In fact, they have spent their first $847 million, and $426 million went to taxpayer services, $315 for operations support, $99 million for business systems, and only $6.6 million for enforcement. Not clear whether they used any of the $6.6 million to buy long guns and ammo, but probably not. In any event, I think for all of us in the room and people listening, there's going to be more work. There's going to be more enforcement. There's going to be more audits, and I think that's a good thing for the country. But we'll see. But he is going to be the next commissioner, and whether he'll take a softer line on conservation easements than his predecessor, we'll have to see. The employee retention credit. Have any of y'all heard all the ads for the employee retention credit? It's they're on the radio, they're on TV, you go to the internet, and there's one where it's a stream of taxpayers, 300,000, 800,000, 200,000, all the money they saved. This is an ad. What is a great way to spend cash and put it right back into your pocket? Spend it on wages, then claim the employee retention credit. It's a great deal and keeps on getting better. You have to know how to play the game, and the rules of the game keep getting better. That's an ad for a seminar, y'all. That's not even designed for the public. And I realize that, you want to make it catchy so people come. our approach to titles is you just don't charge anybody and have a reception afterwards, and you hope somebody shows up. We don't spend a lot of time thinking about the title, do we, Chuck? No, we don't. But this is and stuff like this, to me, a seminar where it says you have to know how to play the game and the rules of the game keep getting better is probably not the best thing for the profession. But nonetheless, it's been heavily advertised. It's part of the pandemic spending. Just to show you how current we are. Just yesterday, the IRS came out with a notice warning on the credit that there's these mills, there's been criminal cases made against the mills. And it's essentially a credit, it's an unemployment tax credit that's refundable. And the reason that I think it generates so much interest is you can be eligible if you demonstrate a full or partial suspension of operations. I am not an expert on the credit. There are people here who are experts, not me. But I think you don't have to show that you lost any money, just that you couldn't conduct business. For example, if you're a litigation firm and the courts were closed. Now, I suspect you might have lost money, but nonetheless, that's not a necessary element of claiming the credit. So there's a lot of gamesmanship you can play because if you had a significant decline in revenues, you qualify, but also if just a full or partial suspension of operations, you can qualify. Am I saying, Mr. Kess is an expert, I am not, but am I saying this properly?
That's one of the elements that goes into determining whether or not one would be eligible for it.
There you go. So I'm not committing malpractice by saying that, which is good. So, and it's just, these things have caught on like wildfire, as I've said. There are mills doing that. The government's made successful criminal cases against some of the mills. The real question from our perspective, the why I'm talking about it is just about all of them, or nearly all of them, the way they're pitched is it's a contingent fee. In other words, you don't have to pay us anything up front. We'll file the return. And I guess the way it works is, and if you get back a credit of $1,000, we get 30% of that. And I guess they pay that when they file the return, or maybe when they get the money back. I'm not sure, but it's a contingent fee. And the issue is, if you're a lawyer or a CPA, is that ethical under Circular 230? That's what I want to spend a little bit of time talking about. I said there are IRS warnings issued in October and March. There's this IRS form 14242, which I'll admit I did not know existed. That it's where you can report someone. I wrote down the title. Reporting abusive tax promotions or preparers. Like, ooh, I tried to pull it off the internet, but it wouldn't print. So there are ways for people to make sure the IRS knows about this. So it's not like you can put your head in the sand. And the issue that I want to talk about is just under Circular 230 and the state of the law. Can you charge a contingent fee for filing an amended tax return, which is what this is? Although I think what a lot of people don't talk about, and I think this is right, Jeff, if you claim the credits, you have to reduce your wage expense.
Right.
It's not a total freebie.
Right. When you receive it out.
Right. And anyway, that's going to be our substantive discussion of the employee retention credit. Circular 230. Hopefully, you all know about Circular 230. It's been around for a while. When I was assigned to OPR and ERSAC, it was basically thought of as the rules of engagement with the IRS. If you practice before the IRS, and you're an attorney or an accountant, these are the rules that govern your behavior. The technical side, 31 CFR 10 to 10.93. It was actually, the reason it's called circular is it was first promulgated back in 1921. And back then, rather than regulations, they had something called circulars. And they issued circulars, and they were sequentially numbered. And this just happened to be this 230th circular. If you violate Circular 230, the enforcement mechanism is OPR, the Office of Professional Responsibility. When I was on ERSAC, I was assigned to OPR when Karen Hawkins was the head. It was very, very active then. I'm not sure it's as active today, but it's about 10, 12 people, lawyers. They get a lot of referrals. They'll get referrals from people that are suspended from the practice for like accountancy. And then they get referred to the IRS, suspended by the bar, taxpayers, sometimes agents, and they can sanction you. They can publicly reprimand you, suspend you, issue a monetary penalty, none of which are particularly career enhancing if you're a tax lawyer. This is a statute that gives the IRS the ability to regulate practice before it. And you will see what's important in this statute is 330A1 regulates the practice of representatives of persons before the Department of Treasury. The practice of representatives, so you have to be a representative of persons before the Department of Treasury. And then, good character, repute, qualifications, all that good stuff. I'm going to skip over this. Circular 230 very, very broadly defines tax practice, compliance, planning, controversy, that's all covered. Historically, prior to 2011, it did not address tax preparation. When I was up there, there was a big, when I was part of ERSAC, there was a big concern among the IRS that there was a huge gap in taxes because of folks like preparing tax returns out of their trunk sort of thing. Unenrolled tax preparers didn't know what they were doing, were gaming the system, playing the audit lottery. One of the ethical, it's in Circular 230, it's part of the ABA rules, applies to CPA rules. You can't play the audit lottery. It's just not ethical. Obviously, if everybody played the audit lottery, the whole system falls apart. And they just felt like this was a huge problem. And they were particularly concerned about the earned income credit. The earned income credit is a credit where if you have just enough income, you get a credit and it's refundable. So the government writes you a check. And they believe there were at the time billions and billions of dollars of returns that were falsely claiming the earned income credit. Just anecdotally, a friend of mine volunteered to do taxes for, I think it's VITA, V-I-T-A, and a lady comes in and tells her about her business. You do like you did last year, put my business down there. And she basically, as it turned out, she basically had manufactured, and the person did it in prior years, a business to show enough profit so that it would generate the earned income credit. It's just one isolated incident, but the government really believed there was just this incredible amount of fraud. They needed to do something about it. So at least let's regulate preparers. If you're a CPA, you're an attorney, enrolled agent, you're already regulated. Let's bring everybody underneath the umbrella. At the time, they set up this mechanism, this infrastructure. They established the Return Preparer Office, RPO back then. They established, they hired, I think it was Anderson Consulting to prepare a test so that everybody would have to take a test that wasn't a CPA or an attorney or an enrolled agent to get the credential to be able to prepare tax returns. It was this huge infrastructure. They spent millions and millions and millions of dollars getting this in place. That's where PTIN started, charging for PTINs, all that. So in 2011, they're doing all this. And in 2000, well, let's talk about this first. So we revised Circular 230, and there's all these rules governing these unenrolled tax return preparers. And I guess nobody stopped to think, well, gee, do we have the authority to do this? One would have hoped they would have thought about that. Apparently not. So what happens? 3 very sympathetic unenrolled tax return preparers file a suit against the IRS and say, look, IRS, all we're doing is we're very simple, humble little tax return preparers. We're not practicing before the IRS. We don't represent anybody. All we're doing is helping people put numbers on the form and send them into you. You do not have the authority under that statute I put up earlier to regulate us. And the case goes to the DC court, district court, and lo and behold, district court says, you're right. The IRS doesn't have authority. And why don't they have authority? Because if you look back at the statute, It regulates the practice of representatives of persons before the Department of Treasury. Well, are you representing someone at that point? I don't know. You haven't gotten a power of attorney, so you wouldn't have any sort of representative capacity there. You're just the hired help filling out the tax return. I'm not representing anybody. I'm just helping them fill out the form, assisting them file their taxes. And then it has to be before the Department of the Treasury. Are we before the Department of the Treasury when we fill out our tax return? I don't know. It's a self-assessment system, right? It's not like the government comes in, we sit down, we negotiate the tax return. You sit at home, you fill it out, you send it in. So that was their argument. And they won. The district court said, you're right. And then that case got appealed to the DC Court of Appeals, and a judge by the name of Kavanaugh, who's now in the Supreme Court, said, yep, district court was right. When you're filing a tax return, you're not technically a representative. You're a paid preparer. You're not a representative. You're not representing anyone. By the way, if you complete a 2848, if you look at it real close in the fine print, you agree to be bound by Circular 230. So once you sign a 2848, you're kind of in the suit. Plus, you can get attorneys, but nonetheless, Kavanaugh agreed and said, look, just preparing a tax return doesn't establish a representative relationship. It's just filling out the form. Also, he agreed, because you're not practicing before the IRS. So that there's the Department of Treasury, you're sitting at home filling out the return. There's no interaction with the IRS until you submit the return and the IRS chooses it for audit and then starts to interact with you. So for those reasons, all the time, trouble, and effort the IRS went into in establishing the Return Preparer's Office, although it still has some functions, but setting up this whole regulatory scheme, paying our Anderson Consulting millions of dollars to set up a test, all that flows by the wayside. Okay. So, and the only way that can change, and this, I don't think they appealed it to the Supreme Court. I don't think so. So the only way it's going to change is if Congress passes legislation which authorizes the IRS to regulate unenrolled tax return preparers. Over the years, since 2013, when this came down, there have been 7 or 8 bills that have been offered. None of them have gained any traction. They didn't even gain any traction when the Democrats controlled all 3 branches of houses. All 3 branches of government, or 2 branches of government, at least the House, the House, the Senate, and the presidency. They still couldn't pass it. They tried, but it didn't work. With the Republicans in control of the House, I think the last thing in the world you'll see is legislation coming out of the House regulating unenrolled tax return preparers. So it's likely going to be that way for a while. So what does all that mean? It means that the portions of Circular 230 that deal with regulation of unenrolled preparers arguably are invalid. So what does that have to do with contingent fees? Well, under Circular 230, generally you cannot charge a contingent fee. It's just generally thought to be, that somehow you don't want, I guess from the government's perspective, you don't want someone's fee to be like, if you're filing a tax return and I'll file your return, but I get 20% of your refund. That's just not a good thing. So under Circular 230, there's a general prohibition against contingent fees. However, there is an exception. There are exceptions to when you can charge a contingent fee. And that's in connection with the examination or challenge to an original return. So if the IRS is auditing the return, you can then charge a contingent fee. And when you file an amended return or claim for refund, but there's this peculiar language in 1027, which says where the amended return or claim for refund was filed within 120 days of the taxpayer receiving written notice of the exam or challenge. What is magic about 120 days? Why not 90 days? Why not 150 days? Why any number of days? When we were up there, we asked Karen Hawkins, who was head of OPR, what is that? Why is that in there? What's the sense of what is the purpose of the 180-day, 20-day time period? She had no idea, which gave us a lot of comfort. But It's just I guess a random number they pick that has no meaning. But that's the rule to file under Circular 230. If you are filing an amended return for a client, just a straight old simple amended return, there hasn't been any, not in response to an IRS action. It's just for whatever reason you're filing an amended return, that would be barred. You can only charge a contingent fee on an amended return or claim for refund if it's within 120 days of receiving notice from the IRS. As I said, I have no idea what the 120 days comes from, but nonetheless, that's what Circular 230 says. And also in connection with any judicial proceeding. Obviously, if you go to court, you can charge a contingent fee. I put up there just what a contingent fee is. It's pretty much what you'd expect it to be, a fee based on a percentage of the refund reported on the return, based on taxes paid, depends on the specific result, based in whole or in part on a position taken on a return or avoids filing it. It's based on a position taken, avoids that it won't be challenged or sustained. So if you look at Circular 230 and 10.27, all the people, if they're accountants and attorneys, filing refund claims for these businesses and charging contingent fee or violating Circular 230, the plain language, because they're ordinary refund claims. There hasn't been any IRS audit. They're just filing a refund claim. However, the plot thickens. After Loving, there was a case called Ridgely v. Liu. Liu was the was the Secretary of the Treasury back then. Ridgely was a CPA. And Ridgely filed just an ordinary amended return, just filed an amended return on behalf of his client. And he he charged a contingent fee, which by its terms was a clear violation of Section 10.27 of Circular 230. And he sued the IRS in District Court of the District of Columbia. And he argued, look, I'm just filing a return. At this point, I don't have a power of attorney. I'm not representing anybody before the IRS. I'm just filing a return. Moreover, the same arguments in Loving, I'm not before the Department of Treasury. You're not coming to my office, IRS, and helping me or watching me file this return. I'm just doing it and we're going to submit it. So how, IRS, do you have the authority to tell me I can't charge a contingent fee when I'm not a representative? I'm not representing anyone at this point, and I am not before the IRS. And once again, the government lost. In Ridgely v. Liu, the court found that that 10.27 prohibiting a contingent fee for an ordinary refund was invalid. And this is a district court of the DC Circuit. So it doesn't apply in the 11th Circuit, but nonetheless, if you ever sued IRS, I guess got into a fuss, you could sue them in DC Circuit, and I guess it'd be controlling law there. Under the APA, you can sue them up there. So you have this situation where you have a prohibition under Circular 230 to charge a contingent fee, but at least one court, the DC Circuit Court, saying it's perfectly fine. What should you do? I really don't. If you're aggressive and don't mind taking a position, and then the IRS did not appeal Ridgely v. Liu. They didn't even appeal it to the Court of Appeals. And I think the reason they did that was they were concerned they would lose. And they didn't want to establish even more bad precedent beyond the district court decision. So it's just a district court decision. It hasn't been appealed. The IRS has not revised Circular 230. I was up there when it happened. We kind of talked about it, but I left ERSAC in 2014. We didn't do anything. And since then, they didn't do anything. So what is OPR's view of this? Well, interestingly enough, just yesterday, hot off the presses, OPR came out with guidance on the employee retention credit. And I've been doing this a long time. I don't think they did something like this for conservation easements, which I kind of viewed employee retention credit as somewhat comparable to, just in terms of the mass marketing, although the ERC is even more mass marketed than conservation easements. But they did come out with kind of professional guidance about the employee retention credits. It's from the Office of Professional Responsibility, issue number 2023-02, goes into the purpose, and then it says tax professionals' roles, and talks about some of the things that we'll talk about, where you have a obligation to make sure that information you're getting is accurate. You can't just accept information from a client without at least vetting it a little bit. You don't have to audit it, but there is a minimum amount of due diligence you have to do. There's rules about relying on written advice, rules about giving advice. So they go through all the things a professional needs to be aware of under Circular 230 to avoid running afoul of the rules for when they're claiming this employee retention credit. Well, notably, in this release, doesn't say a darn thing about contingent fees. Doesn't say, oh, by the way, Circular 230 says you can't charge a contingent fee, but we know everybody is. By their silence, does that mean they've acquiesced? I'm not sure. I really don't know. But I thought it was and as I said, I've rarely seen OPR come out with something like this. Very unusual in my experience, just because these ERC credits have been so prevalent and there's just so much money that's going out. But if you would have thought that if they believed that their rule against contingent fees was valid, they would have stuck it in there, but they didn't. On the other hand, it's still a rule, and it's only the DC Circuit that is that has challenged it. So that struck it down. So, I don't know. I think ethically you could certainly take the position, especially after this came out, that the 10.27 has been struck down by a court. It doesn't apply. I can charge a contingent fee on a refund claim. If you're more conservative, I'd think twice about doing it, just because you never know. And the IRS is going to be looking at this. I have a feeling that these employee retention credits are going to be kind of like what conservation easements now are as far as enforcement. That they're going to be taking a hard look at all these and making sure that people really did qualify for the credit. So I think you don't want to leave yourself exposed to any sort of IRS challenge to your credentials. So something to think about. The other thing I wanted to talk about, and then we can talk about Circular 230, is this attorney-client privilege case that was before the Supreme Court. And it's one of the few times any sort of a tax case has gotten, the Supreme Court just does not like tax cases. And this was a question of attorney-client privilege in the context of tax advice. And it kind of made me think about the privilege and where you really have to be careful. And the question here before the court, which was dismissed, the Supreme Court dismissed this in January. And when they, I'm not an expert on Supreme Court practice, but when they dismiss things, they just write dismiss. They don't have to explain themselves. Can you do that, Chuck, can you just say no and then just, you have to give a little bit of a reason? Oh yeah, they gave no reason. I guess you can, you're the judge. But so they dismissed it. So we don't know. We don't know what the rule is, and we'll get into it a little bit. But the question was whether a communication that involves legal and non-legal advice is privileged. We're obtaining and providing the advice one of the significant purposes behind the communication. It was a case involving a lawyer who was asked to produce documents to a grand jury, and he refused, citing that the materials were privileged, but they were dual purpose. They were not only to provide legal advice, but also for non-legal advice. And the non-legal advice comes from preparing a tax return. When you get information from a client and give advice to preparing a tax return, that's not privileged. I guess I knew that, but I really haven't focused on it. But that's why CPAs don't have a privilege, because preparing a tax return is not privileged. It's not subject to the attorney-client privilege. Any documents, if you prepare tax returns for a client, Any documents that the client gives you in preparing that return are subject to discovery. They're not privileged. That's very, very well settled. I think I've cited a case maybe on the, maybe I don't cite a case, but to take my word for it. And this was a case where the lawyer specialized in international tax issues. And his client was expatriating, giving up either his US citizenship or a green card. And when you expatriate in this country, if you have enough assets, you pay an exit tax. I guess it's the IRS's last bite at the apple, and they're going to get it when you become a citizen of Malta or wherever. And essentially, you're treated as if you sold your assets for fair market value. And I'm not once again an expert in this area, but you sell your assets at fair market value, you pay this exit tax. And it's a pretty high threshold for when the tax applies. You have to have a fair amount of assets. There's also a question as to what types of assets does it apply to. Assets that can be difficult or deferred compensation, where it's a value to be provided to receive in the future. How does that factor into it? So he was giving advice to this client to expatriate, but he was also preparing the tax returns that are filed with the IRS to report the expatriation. And the communication related to both an item on the tax return and also just legal advice. So it was a dual purpose communication, involved legal advice, perhaps what assets are subject to the test, but then he was actually filling out the form. So advice with respect to filling out the form is not privileged. So the communication had dual purpose. And the question is, if you have a dual purpose communication like that, is it still privileged? And I think it's also drafting something to the IRS to abate certain penalties. And there's a split among the circuits. There's kind of a bright line test where if it's used in preparing tax return and used in litigation, it's not privileged. That's the Seventh Circuit. So there's just a bright line, you lose if it's dual purpose. The DC Circuit under Kavanaugh, the court looks to see whether the advice had whether legal advice was a significant purpose. If it was a significant purpose, then it was privileged. That's kind of the DC Circuit Kavanaugh's test. Several circuits, including the Ninth Circuit, where this person was subject to, applied if the advice is the primary purpose. It has to be the reason you're giving the advice. And if you're giving the advice in this context where perhaps you're saying, well, we're not sure if this asset applies and whether how the tax applies to this asset, and here's how we're going to disclose it on the tax return, I think you have a hard time arguing it's the primary purpose. And the lawyer was trying to argue that the court should adopt the significant purpose test, assuming there's a difference between significant and primary. And the court dismissed it, so there's still a split in the circuits. But I think what it kind of brings home is, I don't know if folks here or listening prepare tax returns, but if you've got a client who, for whatever reason, you want to keep materials privileged, you probably don't want to be preparing the tax return. I would, farm that out to a CPA, keep it totally separate. Make sure your advice is limited to legal advice, not anything to do with filling out the forms, because it's too risky. And I'd kind of forgotten that over the years, I think. But and a lot of law firms, for example, prepare estate tax returns, and you get appraisals in connection with the estate tax return. And oftentimes you might get multiple appraisals because you get an appraisal and like, oh, that one doesn't look so good. Let's get another one. Oh, that's better. We'll use that one. Well, is that first appraisal, and then typically if you get audited, the IRS says, we like a copy of every appraisal that you ordered, that you commissioned while preparing the return. And if it's really being used for the 706 to prepare the tax return, that first appraisal, even if the lawyer ordered it and tried to make it privileged, I'm not sure it is. because it's really a part of the preparing the return. So I just think you need to think long and hard. And there may be cases where you just don't care. It's fairly ministerial, but typically if a lawyer is preparing a tax return, there's a reason the lawyer's doing it, not a CPA. And just want to make sure if you're going to do it, do the best you can to separate legal advice from tax return preparation advice. But the waters get muddy real quick. And I think the best course, if you want to be really conservative, is just don't prepare tax returns for clients where you want to keep materials privileged. It's just not worth, it's not worth taking the risk. And sadly, this case didn't clear it up. I just wanted to go over a couple little things about Circular 230 that were not rendered invalid by the courts. One of them is due diligence. And you can't just take information from a client and accept it without at least doing what I might call a smell test, just to make sure that what the client is telling you is right. You don't have to audit, you don't have to, scour behind the facts, but you do need to at least make sure that what they're telling you is consistent, it's credible, it's possible. You just have to be careful. You can't just take what people say at face value. You do have an obligation for due diligence. And, if you're dealing with small retail businesses where there's a lot of cash, you have an obligation if you're preparing tax returns for that business, just, hey, did you get any cash? Don't people pay you in cash? Of course, anymore, maybe not. Non-cash contributions, rental property, that sort of thing might require extra due diligence, but there is a due diligence requirement. This was something that actually, when I was on ERSAC, we put this in 10.35, practitioner competency. There was just no provision in Circular 230 that says you have to know what you're doing. And we thought, well, gee, seems like there ought to be something in there saying you know what you're doing. And Karen Hawkins agreed, so we got the IRS to modify Circular 230. And this may have been the last time the darn thing has been amended to insert 10.35, explicitly providing that you've got to be competent, you've got to know what you're doing. Knowledge, skill, thoroughness. You can obviously, obtain competency by doing research, all that sort of thing. But there is an obligation to be competency. And I think that when the OPR came out with this thing on the employee retention credit, they didn't mention that you have an obligation to know what you're doing, because apparently, I mentioned this earlier with Jeff, a lot of these mills are saying, well, you get this big credit, and not telling them that, oh, by the way, at some point you lose the deduction for the wages, so it's not quite as rich as you may have otherwise thought. So you got to know what you're doing. That's an obligation. I'll skip that. Oh, this was just years ago. This used to be. Y'all are too young in this room, most of you, but back in the late 2000s, there were all these tax shelters, Boss, Son of Boss, and they were a bunch of people in the big four accounting firms, a bunch of really smart people got in a room and thought, gee, let's figure out a way to manipulate the Internal Revenue Code so that we satisfy the literal language of the code, but produce results that are never intended, have no economic substance, but generate huge losses. That's Boss, Son of Boss. I remember back in 2005, 2006, I went to this meeting with one of the big accounting firms, and I had a client. They were pitching this thing with foreign currency and Deutsche Bank, and there was like a 0.1% chance that he might make $100. But by God, you were going to best guaranteed to lose 10 million for tax purposes. And this was just the greatest deal since sliced bread. You remember? And straddles, where the hell they were. You got to do this. And I'm going to this meeting, and it's this partner at this big accounting, well, I won't say the name, big four accounting firm. And I'm like, I'm sorry, but I don't understand that. This doesn't make any sense to me. Oh, obviously, and then I found a way he told my client, well, your lawyer's stupid. He doesn't understand. Unfortunately, my client didn't do it because they were ultimately found to not work. But so as a result of all these tax shelters, the IRS amended Circular 230 had all these rules for opinions Because back in the day when these shelters came out, the lawyers would write opinions and they would say, well, yeah, it kind of, conforms to the technical requirements of the code, but wouldn't really touch on the economic substance. And they really weren't worth the paper they were written on, but a lot of law firms made a lot of money doing those opinions. And judge knows. So any event, so all these rules about tax,
Not any of the lawyers.
not any lawyers in this room. No.
These lawyers.
No, but there was, and it was big money, at the time at least. So the IRS came up with all these rules for written advice, and basically an email could be written advice. And as a result, unless your email complied with if your email contained any sort of tax advice, you had to follow all these rules for opinions, just an innocuous email. And as a result, in order to get out from under the requirements of adhering to Circular 230, people would put this disclosure on emails to ensure compliance with requirements imposed by the IRS. Any tax advice may be contained, cannot be used, blah, blah, blah. And you get this email. This was on every email. You get an email, you send me an email. Let's have lunch. They get back an email. Okay, but you cannot use this for tax advice. It was everywhere. And in fact, I still get a couple of people, you still see it. They're still out there. They're still out there. But all those rules 7 or 8 years ago changed. So if you're using one of these, you really don't need to be using it anymore. You can stop because the rules these were such detailed. It said like the type font you had to use and an opinion, and it was incredible. It was awful. But kind of the old bad facts make bad law sort of thing. So this all changed. Maybe, 10 years ago now. When Circular 230 was amended to really clarify about tax advice. What is tax advice? Pretty much what you'd think it is, applying law to facts. It can be a memo, letter, and email can be tax advice, which is why you have to be so careful what you put in emails. Because I know if I'm busy and I'm trying to, and so I get an email and I want to respond quickly and I dash something off, well, you really need to. In the tax world, so much depends on the facts, and just a little change in facts changes the analysis and the advice. So you have to be really, really careful responding to emails. In fact, I've got I know a couple people at our firm who have their emails on a delay. Like they type the email, but it doesn't go out for like 2 hours, just so they can, to make sure that they don't put the wrong person in the address line, which. Not that I've ever done anything like that. I thought, boy, that's a good idea. But also just to reflect on it a little bit, to make sure that, what you're saying is what you really want to say. So you have to be careful with emails. But tax advice is generally what you think tax advice is. And there's basically under Circular 230, so there used to be all these detailed rules. That's all no more. And this has been around a while. I just wanted to reference it. But there are 6 basic requirements to written advice, and it's all pretty stuff that is you're probably doing now. So it's nothing that's going to cause you any surprises or heartburn. But reasonable facts, legal assumptions, consider all the facts. Probably the most important thing in any sort of a tax advice is to make sure you got all the relevant facts. Make sure you ascertain the facts. Don't rely on statements if they're unreasonable. Relate the law and the authority of the facts. And the most important thing, and this is consistent, I said before, with CPAs, with attorneys, do not consider the audit lottery. It's just not ethical to consider the audit lottery. We have a system of self-assessment, and in order for that system to kind of stand up, if everyone played the audit lottery, the whole thing would fall apart. Because the IRS, now of course with this $80 billion, they'll have greater enforcement capabilities. But look, the odds are you probably won't get audited. And there was a time, the IRS used to be organized geographically, and there were districts and regions back in the late 90s, and they changed all that in the 90s, and they moved to this small business, self-employed, large, whatever, in the kind of industry groups rather than regions. And when they were making that transition, this is 20 years ago, so it's old news.
I guess 20, 30 years ago almost. God, we're so damn. Um, when they were making that transition, they basically poured everybody out of the field to assist with the transition. And then there were 2 or 3 years when nothing got, I mean, it was, shouldn't say that in an ethics seminar, but it's a long time ago. But you can't consider the audit lottery. It's just not ethical. And what I tell people, if they ask me what's my chance of getting caught, say, look, if you don't have to pay me, whatever, just if that's what you want to, if that's your test, whether you're going to get caught, just do it and take your chances. But written advice, the requirements, it's much more straightforward than it used to be. And you don't need the circular 230 thing anymore. Relying on advice of others, there's rules about that. Standards, I'm not going to talk about that. I want to just talk a little bit to finish just about my sense about conservation easements and everything that's going on there. And it's kind of interesting that I remember when these things were being pushed, promoted, and I reviewed some of them, and I kind of fell in the trap that most people did. I looked at them and said, well, I don't know, but what's the worst that's going to happen? So they say you get a 5-to-1 deduction, maybe you'll get a 3-to-1 deduction. That's better than no deduction or a 1-to-1 deduction. So what do you have to lose? And there shouldn't be any penalties. And, as long as you stay reasonable. I always told people, if you're going to invest in these, take the tax savings, put it in the bank, don't spend it because you never know. But, it's one of those, give it a go. And then there were very, very reputable firms that were writing opinions and doing these. Well, of course, the IRS, for whatever reason, it's really when Chuck Rettig, the former commissioner who was the head of ERSAC when I was on ERSAC, and he's a really good guy. He was a tax litigator in California, represented taxpayers, not a government person. But for whatever reason, Chuck and his close advisors believe in their heart of hearts that conservation easements are fraud. They're all fraud. There's not a good one in the bunch. That all this, that taking property worth X and putting an easement on it and then saying that's worth 5X, it's just fraudulent. And there's no way it can be right. So they've kind of taken the scorched earth approach to these things. And they had initially, what they hung their hat on was a provision in the easement, which basically said that if the easement is extinguished, like a utility comes in and buys the property, and the easements all had this provision, which was actually part of a land trust form that I think at one time the IRS may have even sanctioned and then changed it by regulation. But if the easement was extinguished and in the interim you constructed an improvement, unless, and this may not be exactly right, but unless the value of that improvement was allocated to the charity when the easement was extinguished, it's not deemed to be an easement in perpetuity and it fails. And some of the courts bought off on that and said, yeah, these provisions in the easement are bad. These condemnation proceeds and the whole thing fails. And I got to tell you, when I was reviewing these in like 2010, 2011, not in 100 million years did I think about the friggin' condemnation provision in the land trust form, that would be found to be ineffective. Just goes to show, be careful. Had nothing to do with the valuation, because the IRS simply does not have, after the 80 billion, who knows, but they don't have the resources to try all these cases. They don't have the resources to hire appraisers. So this was a very clever way for the government, without having to hire a bunch of professionals, to bring them down, because it didn't involve valuation. It was just a technical provision. But lo and behold, the 11th Circuit found, well, the regulation that the IRS issued that found that these provisions, that this condemnation provision was invalid as drafted, that regulation did not pass muster in the Administrative Procedures Act because there wasn't like some sort of notice and comment provision. And the 11th Circuit, that holds. So that line of attack is gone for the IRS. It makes it very difficult for the government to challenge the easements because they've got to go out, they've got to try to challenge it on conservation purpose. And to the best of my knowledge and belief, I don't think they've had a lot of success on conservation purpose, which of course then begs the question, if these things really are conserving property for the betterment of the world, then why is it such a bad thing? But putting that aside, they have to attack it on conservation purpose, or they have to attack it on valuation. And they just don't have the wherewithal to do it, the resources. Years ago, I had a charitable contribution audit where the government was fussing about the value of the charitable contribution. And went to appeals, and it was kind of towards, and this was the agent, and was kind of towards the end of the government's fiscal year. And they didn't have any money to hire an appraiser, and we won, which was very satisfying. But so they just don't have the horses, the resources to fight all the valuation disputes. There's, I think, 800 or 900 of these, maybe more. They don't have the resources to try them all. So they're going to have to come up with some sort of a reasonable settlement to get rid of them. But if they want to really resolve them, otherwise they'll be going on for the rest of my lifetime, your lifetimes, our kids' lifetimes, who knows? The lesson, I guess, a couple of things. Number one, when people, come up with these tax shelters and they seem too good to be true, and you think, well, the worst that can only happen is, as I said before, you don't get the multiple that you thought you were going to get. There's always some sort of hidden trap where, like this condemnation proceeds provision, that can come back and get you. So think twice about getting folks into these if you're ever asked your opinion. That's my take on conservation easements. I finished my hour. In our low budget seminar, I will now introduce our next speaker. Judge Boudreau. Chuck was a longtime partner at Morris, Manning and Martin, tax partner. In 2012,
2012, I was appointed.
Chuck
13. This is the 10th anniversary of Georgia Tax Tribunal this year.
Chuck was
We started January 1, 2013.
the initial judge for the Georgia Tax Tribunal. He is now retired from Morris Manning at a very young age, and is it's fair to say part-time. I mean, you're now on the bench with Office
Office of State Administrative Hearing
of which the Tax Tribunal is a part.
is an administrative division. Yeah, I'll talk about that a little bit. Yeah, and it's great to be here, David.
Thank you.
It's funny. I have to segue into what David was talking about. David and I, I've seen this when the syndicated conservation easements came out. I said, I've seen this movie before. It was called The Art Tax Shelter. Remember the art tax shelters? And what happened is people were buying art, and then they were giving it to museums, the other thing they were buying was jewels. This was a big deal. You would go out and acquire, because there's a huge difference between the wholesale and the retail market. And they would go buy them at the wholesale value and they'd give them away at the retail value, and the deduction is the retail value. Anyway, government was dying. Government was just dying. I mean, that it was because the resources, the government, even though the government has all of our money, it doesn't have the money to spend to hire appraisers. And again, if you talk to Vivian Horde and people who work in this area, the government just whines all the time about, oh, we don't have this, we don't have that. And there's a lot of truth to that. Okay. Well, this went on for a few years. Jackie Fine Arts. David, you remember Jackie Fine Arts? There was a business. And this is what they did. They went out and they would sell you paintings. So anyway, where there's a buck, there's a way. A long story short, and I forget which of the various, we had tax legislation in the 80s every year. Massive tax legislation, because y'all, who was born after 1982? If you're born after 1982, you have never lived in a rising interest rate environment until the last 6 months. And you get to see what happens when interest rates go up and values go down, because this little thing called the cap rate. Everybody remember the cap rates? Well, nobody's worried about cap rates because we've had zero interest rates for, the last 5-6 years. Now we're going to go back to cap rates, which, and again, my political speech today, I actually think is what has been badly missing for a long time. And a lot of the distortions we've got are because you've had money cost nothing. Well, money costs something now. Well, back in the 80s, it was the reverse. Interest rates were astronomical. And so you could, and inflation was out of control. And so you could take all these deductions and you could get write-offs 5, 6 of one, and you can make money. And that's not the way to be for the system to work. Congress and its infinite wisdom. You know, when Congress gets around to it, they kill it. And they don't just kill it, sort of. They kill it completely. 382, when they wanted to kill NOL carry, trafficking in NOLs, they did it. When they wanted to kill real estate excess losses, they did it with passive activity rules. Well, in the art syndication, they did it with the valuation. They said, we're not going to do this anymore. If you're going to take a valuation for art, you don't have to go through a panel in DC. And so that was the end of that. So this most recent, and I haven't even looked at the new legislation, but my understanding is from the 2 lines I read that there is, if it's more than, you can't take a deduction more than 2.5 times the syndicated cost, which is basically you can't make any money. You can break even, but you can't make any money. And Dave's also right. The government's pattern with tax shelters is their rage, and then they do a bunch of them, and then they get killed, and then everybody loses interest, and the IRS sort of mops it up, and they'll make dirty settlements, and they'll eventually get rid of it. So, when the syndicated conservation easements came out, I said, I've seen this movie. This is the way it's going to end. And they take a few. Oh, by the way, they also take a few people out and shoot them publicly, which they did, and to scare everybody, which is one of the biggest problems with our tax system now, because enforcement is so lax that once they have to, when they go after people, if you are unfortunate enough to be the target, they will pummel you into the ground to make sure that everybody knows that if they catch you, they're going to punish you. It's sort of like public execution. That's not rational. The things they go after people for and the punishments are disproportionate, but it's because they can't punish everybody. So they just pick a few people and shoot them and then make public examples out of them and try to intimidate them. What we have needed for a long time is good old fashioned reasonable enforcement. And again, I've been a tax practitioner back when we actually had audits, and we would actually go in and have cases and we get them resolved, and the system worked well, but hadn't worked well for 30 years. Enough of that tirade. As I mentioned, the tax tribunal is 10 years old this year. I was actually sworn in December of 2012, which seems like a million years ago. And we opened our doors on January 1st. I was there for 13, 14 and the first part of 15. And then I went back to Morris Manning to do REIT work, and Judge O'Neill took over. The tribunal continues to chug along. I tell people that the function of this is a little bit of an aside, but the function of the tribunal and the greatest value the tribunal brings, and indeed I would say probably the greatest values that courts bring. Why are courts important? Courts are important because they make you behave. That if you don't behave, the cop's going to have to stop you and look at what you're doing. Well, the tribunal looks at what the Georgia Department of Revenue does. And those of us who've been around a long time, David can remember, I won't call him by name, but there was a certain, I forget what his position was, the director of corporate tax, who did at the department that for years it was notorious because the way he dealt with every case he didn't like was he just sat on it. I mean, he would have these corporate taxpayers, and he knew he would wait them out. And eventually Bell South or Coca-Cola or Delta, or whoever you're talking about, they get tired and they say, settle the darn thing. And the lawyers would be saying, well, that's not correct. And the answer is, we don't care. Get on with it. The tax tribunal was put in place to stop that. And it has done it. And it has done it by not doing anything but being there. As I say, it's like the trooper who is sitting on 20 or 75, and it's amazing everybody slows down the speed limit or much closer to the speed limit. That's, again, part of the greatest value the tax tribunal brings. The corollary of that is one of the old cliches, which is absolutely true and which we have lost sight of, and which I find distressing, is justice delayed is justice denied. It's going to take you 3 to 5 years to get a decision in your case. you're screwed however the case comes out. That's not the right way to do it. Now, the government gets screwed too. Because if you don't get cases resolved, again, people wear out, resources disappear, witnesses disappear. And the great thing about the Georgia Tax Tribunal and the Office of State Administrative Hearings is they are fast. And I haven't talked to Judge O'Neill recently, but the goal is to have every case out of the Georgia Tax Tribunal within a year of the 90-day stay. And I'll talk about that a little bit. Similarly in OSA, I mean, I got people all over me if my decision isn't out 30 days after the hearing. Now, U.S. Tax Court, they haven't even gotten the record finished in 30 days, not much less 90 days. And one of the things I find distressing is when you read tax decisions is the date of the transaction. They're 5, 6, 10 years ago. That is ludicrous. Everybody's gonna be dead. You know, nobody's going to care. So I'm a firm believer that you have to move things forward. By the way, everybody watched the Netflix. I think it's Netflix on the Madoff scandal. Anybody watch that? I think it's quite good because I had not thought about this a long time and we watched it the other night. Does anybody remember the name Stanford? There was another crook. Stanford would have been the greatest fraud in American financial history had it not been for Madoff. He only stole about $1.7 billion, unlike Madoff, who stole, what was it, $49 billion. I mean, and that was back when $1 billion was real money. Well, anyway, the last major Stanford litigation just settled last week. That goes back to 2008. I'll bet you a lot of the people who had claims are dead. It's probably their grandchildren who are getting the money, if anything. That's not good. That's not the way things are supposed to say. I must say, I thought the Madoff, one of the interesting things about Madoff was that the receiver, where you like him or don't like him, whether you like the fact that he made $1 gazillion or $1 billion doing it, he got the money, he got it quick. So there's a lot to be said for justice delayed is justice denied. So don't let it be delayed. Okay, enough of a harangue. OSA. I am an administrative law judge with the Office of State Administrative Hearings. Everybody thinks, and I get this, oh, you work for OSHA. I said, no, that's the Occupational Safety and Health Act people. I work for OSA. So, and they say, well, what's that? And then we do this long shtick. And so what we've started doing is we now internally, if you file of something in OSA, you will find that we are referred to as the court because people understand when you say administrative law court. They don't understand when you say it's Office of State Administrative Hearings. OSA has been around since 1995. It is Georgia's central panel. And by the way, when we talk about OSA, then I want to talk about the tribunal, but they share administrative litigation of any sort is very different from Superior Court litigation, from federal district litigation. It is very, very, very different, and it is much quicker. And if anything, it probably has overtones of bankruptcy. It's a little bit of cowboy court. You know, we're just going to go in and tell the judge what the story is, and we're going to get an answer, which has a lot going for it. But OSA is what's called Central Panel Administrative Law Court. We hear cases, all kinds of cases. The vast majority involve a citizen or a business and a dispute with the state. Now, there are exceptions. Let me give you a couple of exceptions that are important. One of them that is an exception is the Medicare, Medicaid refund statutes that, you know, when suppliers get audited, the fight there is between the federal government and the Medicare provider about whether they can come back and recoup, you know, Medicare payments that were improperly used. Another one we get, which is interesting, is what I call long-term care. And we have all kinds of wild stuff. People say, what are you doing? I said, well, it's kind of pretty wild. If your grandmother is in a nursing home facility and your grandmother is difficult, dementia, or just your grandmother is, you know, what is it? A grumpy old person is a crowning achievement of the devil. There are a lot of those people out there. Some of you may know some of them. I try not to be one. My fiance periodically says, remember a grumpy old person? Yes, ma'am. But if you are a grumpy old person, or if you're slightly demented, or if you have issues, you can get kicked out of your nursing home. but there's a thing called the Long-Term Care Bill of Rights. Nursing homes can't just kick people out for the heck of it. They have to have a really, really good case to show that they can kick them out. Well, those cases are not fights between the state of Georgia couldn't care less. The state of Georgia is really just the referee. The fight there is between the family of the resident and the facility, which, and believe me, those are wild cases. Another kind of case we hear, which is, the three worst kind of cases I've ever been involved with. The three are, the first is a divorce, which is, as I say, I've learned everything I know about domestic relations laws at extraordinary cost, and divorce. The second one is a state administration, which goes sour. There's a quote which is attributed to Mark Twain, although I cannot find he ever said it, but it's a great quote. It says, "You really never know someone until you've shared an estate with them." And having sadly, I'm sure David has never had that experience with any of his clients, because all of his brothers and sisters and uncles and aunts love each other and would never do anything untoward like rush in and get the family silver the day after grandma dies. Or divorces, okay, estate administration. You know what the third one is? The third one is a case we have to hear. And it's the DOE cases involving the IDEA, which is, I can't remember the acronym. Anyway, it's special ed. Squirrel, I look it up. That's why God invented the phone, so I can look stuff up, which I can't remember anymore. But in those cases, what you are, and what are these cases? They're the cases where someone's got a child who is struggling in school, and the issue is whether the school is providing a free and appropriate public education. Those of you who are old enough to remember the second President Bush and No Child Left Behind, that's the genesis of this. And it's certainly laudable. It's a laudable statute with an admirable goal. But unfortunately, the way these things usually play out is by the time they get to us, you've got this parent who has just lost it, understandably, because they've been a victim. They're just in, it's like being in the chat bot when you're trying to get the answer to your question, anyway, you can't talk to a human anymore. I can't fathom the hotel business. I literally had to make 2 reservations on different days because I couldn't figure out how to change the first one. But you've got people who are at the end of their rope administratively. And then, of course, you've got the bureaucracy of the school system. And everybody is just beyond themselves in terms of they have no patience. And they're in there. And it's sort of like, okay, folks, could we all just take a deep breath and sit down now? Because people come in and I say, listen, you need to understand, this is a Judge Malahy's speech. I didn't make this up. But, when parents come in, and I have a number of speeches, I say, listen, I'm here. We're going to get through this case. But what's really, really important is you need to remember what's the point here? The point here is not who's right or wrong. The point is, what does this child need that the school isn't providing that the school is required to provide? And you'd be astounded how so often people have just lost control by the time they get there. And yes, sir. Oh, yeah, Richard Littman. Yeah. That's a very important thing about both the tax tribunal and the OSA. About probably 3/4 or higher of our litigants are individuals, pro se. And in special needs, and again, what's the worst of all possible worlds? The parent doesn't have a lawyer, which is really, really tough. So I have a lot of, when we talk about professionalism today, which is what I'm really supposed to be talking about, I bring my experience with professionalism, and it is, and what lawyers need to do is it makes you very sensitive to the importance of remembering what your role is and remembering what the goal is here. And now this is another important point. When you are dealing with the government, whether it's the IRS or the Georgia Department of Revenue, or you pick your agency, one of the things that is something they need to be reminded of periodically is this is not about winning the case. This is about getting to the right answer. And if you, in the canons, this is pretty clear, for instance, that government lawyers are not just about winning the case. They also are required to try to get to the right answer. Reminding people of that periodically can be very beneficial, and that's also professional. Let me, and in the materials, you know, I'm sure y'all are going to sit up tonight reading them word for word, but there's a tension between professionalism and ethics. I mean, what's the duty of an advocate? The duty of an advocate is to represent the interests of their client zealously, right? What's the duty of professionalism? Professionalism is to behave with courtesy and professionalism and do things the right way. There are people who think those two are actually very much in conflict. And I would say, based on my experience over the last too many years, there has unfortunately been a drift away from the days when the profession was more professional. And there's been a drift very much in the direction of it's all about advocacy. And the more virulent the advocacy, the better. Well, I can assure you that is actually a very short-sighted decision sitting from where I sit. There's nothing that's going to blow up in your face worse than if you are unprofessional in your conduct with your opposing counsel. I will say, my experience with, you know, David was talking about the IRS and certainly the IRS counsel. It used to be that, well, in the IRS counsel, it used to be, they were more balanced. I think that they have unfortunately been forced into this more extreme advocacy by some of the extreme advocacy of the private bar. But at least in the state of Georgia, most of the assistant AGs really are total pros. And they get it. They understand that their job is to get to the right answer. And I could call names, and I have commended several of them from time to time about the way they handle their cases. They realize that one of their most important responsibilities is get to the right answer. And one of the differences between what we do and what you do in superior court or in federal court and administrative litigation, as I've said, is cowboy court. It's show up and tell me the story. In administrative litigation, under OSA, there's almost no discovery. You can do a subpoena ducis tecum. Okay, so you're going to do a subpoena ducis tecum. They're going to show up at 10 o'clock and you're going to review the documents and you're going to have your hearing. Do you think you're going to get a lot of preparation time on that? So it's a different kind of litigation. The tribunal is different. The tribunal is under the Georgia Civil Practice Act. And so basically you've got potential for extensive discovery. But I know Judge O'Neill, and certainly my position about this is, I don't want to hear about discovery fights. This stuff needs to get done. It needs to get done in advance. And let's not waste our time on discovery. That is certainly the case in going to be an administrative litigation. And I would encourage you to remember that. A couple other things. And there's just some, I want to just mention some of the things that OSA hears that you'd be surprised. Of course, most of you know, if you get busted for DUI, you're going to have a criminal case. But what you probably don't realize is that you're going to lose your license. Is going to be something I decide. And the reason for that is you lose your license because you basically are under, you're under the you know, you refuse to take the test or you flunk the test, which goes back to Governor Miller, by the way. That was Governor Miller came up with this regime. We hear those cases. Now, in the real world, what happens is we really piggyback on the underlying criminal case, but we are the ones who actually make the determination about return of licensing. We hear one of the largest portion of our cases deal with benefits, SNAP, AKA food stamps, which is just constant. I mean, there's always kinds of problems with this. And the other one is TANF, which used to be known as welfare. We get those cases about qualification. We deal with a lot of cases involving the Department of Public Health or Department of Community Health, rather. Things like, again, those of you who have older family members, you have family members who receive in-home services.
그 둘이 얘기를 할 때 그 새로 들어올 둘이랑 지금 사는 이재희 선생님이랑 얘기를 할 때 그렇게 얘기를 하니까 이제 이 사람들은 정말 더 있을 거면은 이제 자기네들은 다른 집을 알아봐야 되니까. 근데 그거는 뭐 우리가 그냥 다른 사람한테 기회를 주고 싶다고 기회 주는 거 아니야? 이게 뭐
But I got to tell you, I spent my entire professional life as a lawyer manipulating abstractions and getting paid a lot of money for it.
서로
none of the
서로
problems,
불편할 수도 있겠다 이거지.
passingly few of the
그럴 수도
problems
있지.
I
그렇게
ever had to
얘기하면.
deal with were real people with real problems.
그
At
상관없지.
OSA,
알았어, 내가 한번 물어볼게.
what we see every day is real people with real problems. I used to tell Louise Wells when she was managing partner at Morris Manning, I said, Louise, anybody who's, I started using a more colorful word, anybody who's less than satisfied with their compensation or has any issues just needs to come down and listen to a day of what I listen to in a typical calendar, and they will get an attitude adjustment right away, because these are real people with real problems. These are people, you know, $150 is real money. And it is refreshing to be involved in a role where what you are doing is helping people get through the bureaucratic blockade and get stuff resolved. Just as I said, the tax tribunal is the trooper parked on the interstate. It's also problems resolution. Same thing with OSA. Many, many times the hearing starts and it goes from being, it becomes a mediation session. And again, one of the things in an administrative setting, the judge can and often will be much, much more involved in terms of trying to set the table to get stutters resolved. I had a hearing recently with a terrific, and the litigants walk in and the AG's there. She's terrific. I've seen her many, many times. And the lawyer, the petitioner has a lawyer, and it turns out they've never even talked. And it was not the AG's fault. And the petitioner had never bothered to even reach out. Well, after about a 2-hour hearing, I look at the petitioner and say, why, ma'am, you need to tell me why I shouldn't just remove your license instantly. I mean, this was just egregious. It wasn't even close. And to make a long story short, I looked at the AG's office and said, could we do something like this? And she said, yes, we could, and da, 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 da. And I said, well, y'all got a month to try to work it out and then come back. Those are the kinds of things we can do because we're in an administrative situation where we don't have a jury. And again, it was refreshing to see the lawyers, and they both did exactly what lawyers need to do, is they focused on how to get it resolved. Let's see, another thing we do a lot of, I mentioned the long-term care cases. We do the Medicare, Medicaid, clawbacks. Basically, the federal programs can go back and audit back, I think, 3 years at any time. And claw back where they think wrongful payments have been made. Very complicated cases. And we hear those cases. And as I said, and the other practice pointer is if you are having chest pains, do not let them run the way they do it with the dye, and they take the picture of your blood until after you've been admitted. Because Medicare will not pay it if you're not admitted. But it's just, but if you're already in the hospital, they can do it. I actually had a personal experience on that one. One area of tax litigation I still get to hear, and Judge Malahy gives me anything that looks remotely involving tax or the Revenue Department gets assigned to me for obvious reasons. One area that we do have jurisdiction over is the unemployment tax area. And you might ask why? Why did that not go to the tribunal? And the answer is, interestingly enough, I didn't know this. You probably don't know this. The unemployment tax litigation is confidential by federal statute for some reason going back to the 40s. So I get all those cases, and I can't talk about them with any degree of particularity because they're all confidential, unless they go up on appeal, in which case everything becomes public record. But the Department of Labor is not real fond of appeals, so it's almost always taxpayer appeals. And that only means the taxpayer's lost. So when the taxpayer wins, obviously nothing ever happens. But some of those are quite large and can involve real money. And one of the issues that comes up, and I can say this, is successor ratings, which can be real money in the M&A business. But if you have a problem with the successor rating and that goes up in the department, I hear those cases. We hear all kinds of environmental cases. The DNR comes out and says that you got to spend, and this happens, $1.5 million repairing the retaining wall for your pond. And you say, I don't think so. We would hear those kinds of cases. That recently, Judge Stephanie Howells, I don't know if any of y'all followed this, but it's been a nightmare for for 4 years now. The CBD, Georgia has legalized, medical CBD, and but the licenses couldn't get issued because there was so much fighting going on. And anyway, long story short, Judge Howells, those cases were all consolidated and sent to Judge Howells, and they're now on appeal. But so we get some big stuff like that too. OSA has a caseload of, last year was 29,344 cases, which was roughly 2,600 cases per judge. That's a pretty incredible statistic. But OSA, like all courts, you know, the vast majority of cases settle. You know, I think the rule of thumb is 97% of the cases settle. Literally, you have 3% of the cases that will end up with some sort of adjudication or involvement from the court. Oh, you know, I don't have recent stats, but they run, and I'm sorry, I just don't have them. But I will say this about the tribunal: it's the vast majority of the cases in the tribunal are income tax. The vast majority of the income tax cases arise from credit issues. That about, did you get the credit for the payment? Was it credited to the wrong year? The vast majority of those cases are computational. And so it's interesting. It's surprising how many of them are that way. And the vast majority of those get resolved during the 90-day automatic remand. Those of you, if you're familiar with the tribunal procedure, when you file, there's an automatic 90-day remand to the department, which again, one of the most valuable things about the tribunal is by the time it gets there, you finally got some people who know what to do and who can do more. I mean, you know, as I say, the tax system is a system designed by idiots to be run by geniuses. I mean, it is superhuman to really do everything the tax system says do and do it right. Same thing is true of the welfare system, by the way. Those of you who've got kids applying for college, trying to get your food stamp application in is sort of like asking for financial aid at your favorite college or university with even more verification in terms of income and the like. And so a lot of folks just can't cope with it. Again, one of the great things about the appeal to OSA is when it comes to us, basically the department has a senior group of managers who will go out and be there for the case, and they usually can solve the problem. I mean, 90% of the time they can solve the problem right there. Or they say, you know, Ms. Smith, I'm sorry. And this speech happens all the time. Ms. Smith, I'm sorry. You just got your Social Security raise and it bumped you out of your qualification for food stamps. Happens all the time. Ms. Smith, you know, and she says, well, I need food, and da, da, da. And Ms. Smith says, Judge, is that right? And I said, Ms. Smith, I agree with you. It's not enough, but we don't set the numbers and we don't make the rules. So you need to write your congressman. But that's the rule. And that's all the petitioner needs to hear. They just want to hear from somebody who's independent that that's the correct answer. I had the same experience in the tax tribunal. Many times, you know, the taxpayer would say X, the government department would say Y, and they would say, and the department would say, well, this is the law, blah, blah, blah. And the taxpayer would say, is that right? I said, yeah, that's the law. I said, you know, and they said, okay, well, I'm done. That's really all they want to hear. They don't need a full-fledged hearing. Now, then there's some big cases, but those are the exception, you know. I urge all of you to use, I mean, it's a great resource. OSA is a great resource. One of the things that changed 3 years ago, you can now initiate, the department doesn't have to initiate the litigation. I mean, I've got an interesting case. I've got a call on whether I've got this guy who has an appeal on he wants to record a title to an off-road vehicle. This is not confidential, but he wants to record a title on an off-road vehicle, and the Department of Revenue says the vehicle doesn't qualify. And so it's in the nature of a declaratory judgment action. So it's pretty esoteric, but the really esoteric question is whether it's justiciable at this point. So I've asked for briefs on that issue. So we get, I mean, you get some pretty wild stuff, even though it's very practical, it's also very esoteric sometimes. Let me mention one thing, and this is a broader issue, and that's the issue of non-lawyer participation in administrative cases. And by that, I mean both the tax tribunal and OSA. Georgia has a fairly well-developed jurisprudence of the unlicensed practice of law. And it is crystal clear that if a judge believes that that is what is happening, the judge is supposed to report it to the state bar. I mean, we've had this issue come up a number of times. Having said that, there's also a gray area in administrative law practice. And it's sort of like David's comments about Circular 230. And when do you step over the line from being a tax preparer or an advisor and into the role of being an advocate? And that comes up with us constantly. And one of the issues that comes up here is sometimes interested parties, again, go back to DOE litigation where you're dealing with a pro se petitioner in a special ed case. And they'll basically try to disqualify the advisor. We had this come up literally a couple of weeks ago where the child had just turned 18, so they were sui juris. The parent had been prosecuting the case, and the lawyer moved to sequester the parent, so the parent couldn't be there for the hearing until after the parent had testified. And one of our judges said, well, that just ain't right. Long story short, after we looked at it, we concluded that was correct, that under the rules for the management of a hearing, the court can decide not to enforce the rules of sequestration, which is, of course, normal. So we did that. Where it gets dicier is, and there are these people out here, and they're companies, for instance, who represent people who have issues with benefits and they come in and they help them. And it's a very fine line between helping them figure out and prepare their application and appearing in front of us. We struggle with that all the time. One of the issues, where does that tie into professionalism? Where it ties into professionalism is that it's been very interesting to me that most of the attorney generals, special assistant attorney generals who do this litigation, understand that it's often in their best interest not to disqualify somebody who's gray, because it really helps sometimes to have somebody there who can explain to the petitioner. But it comes up all the time with families where English is not the first language for the petitioner, and they really are relying on the children who are more fluent. It comes up with advocates for special ed. It comes up with accountants. It comes up in front of me if I'm doing a DOL case, an unemployment tax case. It comes up in the tax tribunal. The tax tribunal statute has a limited carve out for the involvement of accountants. But basically, it's a limited, it says, and I'm paraphrasing, the accountant can appear to explain the taxpayer's position, but the accountant is not a lawyer, and the accountant is not permitted to prosecute the case. Having said that, if you're in a phone conference and it's a pro se petitioner, I've never seen an AG say, well, so-and-so is disqualified from participating, because the AG knows that they've got to get the matter resolved, and the accountant is really much more helpful than obstructionist. So with all that said, the non-lawyer participation in administrative litigation is something you need to be thoughtful about. And about thoughtful, I mean, you really need to think it through. And you got to figure out how you're going to do it with complying with the rules and the law as well. So Richard asked me about, and I made the point before, tax tribunal, the vast majority of cases are pro se. The vast majority of those cases are pro se. Doesn't mean we don't get big cases. I had a fascinating case involving an administrative investigation of whether one of the major pharmacy companies was complying with the prescription rules about its records that it did in filling and writing prescriptions. I mean, it was wild. By the way, best case I have ever heard from the point of view of the petitioner. It was just, I mean, they did it exactly the right way. They first of all, as Judge, what is it? What do you call a lawyer who doesn't know anything? Answer, a judge. They realized that I didn't know anything about this subject except when I go to get my prescriptions filled. That was about as far as they knew. And they just laid it out perfectly from start to finish. And they had all the pieces in place. And by the time they finished, it was like, why are we here? This is clearly the right answer. That's the way to present a case. One of the biggest, and this is true of any case, one of the biggest problems I have is people come in and they start, first of all, they start talking in jargon. You know, they start using acronyms. And I've learned a lot of them, but I say, could you put that in English, please? And then they assume you know something. I don't know anything. You know, no, I don't know that, you know, Sally, you know, shot John 3 weeks ago. No, I don't know that. You got to tell me. From a professionalism point of view and out of respect for the courts, you really don't need to insult people. You know, you can, but you need to make clear that you make it easy for the court to know where you need to get to. We're non-jury, I belabor that point, but we are very flexible. Oh, let me mention the subject of virtual hearings. I am a believer. I was not a believer until the pandemic, but OSA, by the way, we didn't miss a lick. We basically shut down March of 19 for about a month while, you know, everybody's trying to figure out what are we going to do? Well, by the end of the month, we were back in business and we had flipped over to basically virtual hearings. And as my son, who works for Salesforce as a software engineer, will tell you, I am not very talented when it comes to dealing with technology or software. But even I learned how to deal with it. Even I learned how to do Zoom conferences and how to do hearings. And it made me a huge believer out of that tool. Because, and this is one of the things that surprised me, is you have a very different experience of a hearing if I'm sitting here and the witness is here and I'm listening in my right ear, which is my good ear, and I'm writing and taking notes. I have a very different experience that if I am sitting here looking at my screen and the witness is looking at me in the face. It's very interesting. You have a different takeaway of what the witness is like. I find it's a lot easier to see when people are lying when you can look them in the eye. It's usually pretty easy to figure out, but that's interesting. I'm a big fan of both virtual hearings and I'm a big fan of hybrid hearings. I mean, we were having a hearing the other day talking about a hearing, and I said, and one of the parties is out of state. Well, I said, of course I'm going to let them appear telephonically. I mean, you know, or virtually. I said, why would I'm not going to make them fly to Atlanta to be a witness. That'd be ludicrous, especially when it can be done well and efficiently. So from the point of view of the takeaway for that, for administrative practice is don't assume you can't do these things. You know, reach out to the judge, reach out to the judge's staff. By the way, different judges have different attitudes. And I know there's some lawyers who swear up and down they need to be in the room to cross-examine. OSA litigation, you know, one of my fellow judges has a great quote. We were in this program and he said, okay, is a DOE case, I talk about these, is it one of these special ed cases? Is it a PTA meeting or is it a murder trial? Well, the answer is it's neither one. But the point is, it has to be tapered. You have to shape the proceeding to achieve the goal, which is to get the record developed and get the decision made. Another subject. I find in administrative law, and I found this it's not so much a problem in the tax tribunal because tax cases, the vast majority of tax cases ought to be resolved on motions for summary judgment. I mean, if you're not arguing about valuation, which is where you need to see the witnesses, the facts are the facts. I mean, the tax return says this happened, this happened, this happened, I don't know why we need to spend, several days of testimony if we can agree to it. And by the way, I really sit on litigants about stipulations because why are we wasting our time? Just tell me what the facts are, and then we'll argue about what's a factual issue. But it's very important. And again, this is an issue of professionalism. There are a lot of lawyers who won't agree what time it is. They just won't agree to anything. I don't think that's professional. I don't think it's in the lawyer's best interest. I don't think it's the way cases should be done. So I would encourage you as advocates to agree to things. I'll come back to that in a minute on something else. Hybrid hearings are great, and you should be open to them. But the key there, and the other thing is, there was my former law partner. I don't think it was John saying, but this is an old marketing saying. David's probably heard this one. I'm sure Jeff's heard it. What is it? Never, I'll screw it up. Never write when you can call, and never call when you can visit. Anybody ever heard that one? That's a good rule when it comes to litigation, and especially motion practice. I mean, and I had this happen the other day, and I was not happy. I've got this flurry of papers going back and forth on what seems to me to be a fairly silly issue. And I sort of said, so I told my case management assistant, I said, set up a call. Get these people on the phone. This is ridiculous. I mean, don't send me a brief when all I need to know is what's going on, and we can decide it right then. Especially in administrative litigation. This is also true of tax revenue. I mean, I know Judge O'Neill would much rather get it worked out with a phone conference than have to have scheduled as part of a hearing and have briefs on it if he doesn't have to. Similarly for OSA, if you've got a preliminary motion or something, get in touch with us and let's see if we can't figure it out. This is an interesting comment about contingent fees. Made me think of it. There is a certain organization that some of you probably have had dealings with that I think they're based in Texas, and it's a law firm. And their modus operandi is to go in and go to public companies that have audited financials and say, give us your tax returns and let us see if we've got any refund. David knows what I'm talking about. And see if we've got a good refund case. Well, I've had them several times now. They're good. They're very good. But the issue of the contingent, the ethics of the contingent fee award, because they're working on a contingent fee. I think they've figured out they can do it, David, and they're law firms, and it does involve litigation. So that would be okay, right? Although there's, again, an interesting question. Anyway, it's very interesting, though, when you see those cases, because the behaviors are very different. What's also very interesting is that you get the issue of the consultant who is not a lawyer, and to what degree can they be involved? Again, if you find yourself in that situation, you need to be sensitive to the issue of when is a consultant moving from the role of being a consultant to being an advocate and a potential witness. And then David's points about the privilege or lack thereof. I've never figured out what, the people talk about privileges in tax cases. I say, what privilege? What is it that's privilege? What is it that we are arguing about? It's a tax return. You help them prepare. All right. I also used to say when we did this live, first time we've done this in 3 years, that, this is sort of like going to church. You know what the preacher's going to say, but you go so you can be reminded again. I'm sort of here to remind you things I want to mention that are good rules. And I did mention there is a tension between zealous advocacy and being professional, but I'll tell the story. And, I had my 15 minutes of fame is coming on because of the Marjorie Taylor Greene case that I had, which, by the way, was the first adjudication on the merits of the disqualification clause under the 14th Amendment since I think 1878. And that issue is very much alive and well. And I suspect we will see that matter litigated again. I will stop there. But one of the really rewarding things about that experience was the advocates were, I mean, I don't know if any of y'all watched it. I mean, they were very zealous in their representation. I mean, they were, go, go, go. And this is where you got to view the facts and da, 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 da. What was fascinating was how professional, that's just the right word, when we were not in the public eye. I mean, we had numerous conferences because, they had an exhibit book like this and, videos and stuff, sort of like incoming. I remember very vividly one day we were talking about something and one of the advocates said, and I can't remember which side was, we can't find X. And could the other side, could you send it over? I said, sure, boom, right then. I mean, they were completely professional in the way they handle themselves. I will mention, I think his last name is Bob, James. I think it's James Bob. But the guy who represented Ms. Green, who's also represented Madison Cawthorn, and I believe has had to pursue Mr. Cawthorn on his fees. But he is, first of all, he's terrific. I mean, terrific guy, and he plays the aw shucks, I'm a country lawyer. And then you look at his dossier, and he's argued in the Supreme Court multiple times, and he's won. I mean, when the lawyer says, "I'm just a poor country lawyer," put your hand on your wallet because it's about to be picked. Well, he's a terrific lawyer, but it was very interesting. At one point, I was talking to them, and I said, "Listen, I really appreciate the way all of you handle yourselves about this." And he said, "Look, I was a debater in college." He said, "I could argue their case too." I mean, he understood that although he really, really believed what he was arguing, he understood that there was an opposite side. And I think the essence of real professionalism in any kind of litigation, but particularly in administrative litigation, is you have to keep your mind open to the possibility of, well, what if I'm wrong? And how do I deal with this? And again, some of the best advocacy I've ever seen, but completely professional. You can, as people say, you can disagree without being disagreeable. You don't need to snarl just because you can. I would encourage you. So courtesy is, I think, what is it? I think it's Wells Fargo courtesy. That's our motto, or summed up in one word. There's a lot of that to professionalism. Thoughtfulness. This one really bugs me. Yesterday, I don't normally get treated this way. I had an ALS calendar, and the trooper didn't show up. And he sent his buddy in to ask for continuance. Well, the continuance wasn't timely, and that's not the way to do it. I mean, and the reason he wasn't there is he was in a training class. And I looked at the other trooper and I said, "Okay, I don't think they scheduled the training class last night at 5 o'clock, did they?" And he said, "No, sir." Anyway, long story short, I granted the continuances just because those guys work hard, and I try to take it into account, because usually they're coming to my hearings after having been up all night because they've been out, patrolling. But don't do that. Don't let your clients do that. Don't call the night before and say, "We didn't get a hold of the witness." And don't call the night before and say, "We've settled the case," and not bother to call the people that you subpoenaed. I mean, we tend to live in our own little narrow world. And I think it's very easy for us as lawyers to forget that our actions or inactions can have a repercussions in terms of the experiences of people who are dealing with the legal system. So just think, and let people know if there's a change. Similarly, don't wait till the last minute. Document exchanges. I mean, again, I always get annoyed when people walk in and say, "Well, have you given your copies of the documents to this?" I know. Well, and by the way, as I said, it's cowboy court. If you don't ask, you don't get it. If you don't work it out in advance, you show up and you try your case. So, but the same thing is true. Don't wait until the last minute on any kind of discovery or any kind of stuff of that sort. Again, all of you had this in your trial practice course. I mean, it's like, just do what your professor said. Get your exhibits organized, get them labeled, exchange them, make it easy. The first rule, the first rule of effective advocacy, make it easy for the judge. Don't make the judge work. If you got a case, for morons like me who are not teching, you can't go pull it up on, hand it to me, that kind of a thing. Make it easy, especially if it's an obscure case or it's a case that's not going to be readily available. And do speak. Professionalism is, I cannot imagine, and it happens all the time, that lawyers have never talked. It's like, you've never talked, not even introduce yourselves. You need to talk to the opposing counsel, especially in government litigation, because the AGs are busy, but you need to establish the contact. It will help you. It will help your client. That's professionalism. Corollary is we're a non-jury court. Administrative law is non-jury. This is not Perry Mason. Drama is not going to get you anywhere. I have seen very effective cross-examination, which is where, basically the witness has been saying A, B, C, D, and E, and then the AG presents, well, but what about this? No histrionics, and you just watch them wilt. I mean, you don't have to be melodramatic. We get it. We understand. We figured it out pretty quickly. So you don't need to raise your voice. You don't need to be melodramatic. Just, that's the best way to do it. Theatrics are not good. Build the record. In administrative, again, as I said, judges don't know nothing. We don't normally have a lot of hearing, and tax tribunal is the same way. It tends to be a lower discovery court, although the big cases are going to have case management orders, just like you would in Superior Court. But generally speaking, just make sure you bring everything and get us everything and get it labeled. As I mentioned before, I encourage people with the professionalism point of view to use administrative staff intelligently. They can't give legal advice, but they're very practical. They'll say, well, if you want, do you want me to schedule the judge, something for the judge, or how do you want to handle this? Do that. And I've given my little story about don't write when you can call. Again, neither Judge O'Neill or I are fans of discovery disputes. Work them out. Work them out. If we will not be happy if we have to deal with them. And I've fussed about last minute. Don't be last minute. Okay, I've talked about unlicensed practice of law, and again, and that does tie into the privilege issue as well. I mean, be careful who you're using and how you're using them. And again, you're going to find it tough to maintain any kind of privilege if you're using third parties. I talked about sequestration. One thing people don't, I mean, the rule is that the party is entitled to be there. When the party is the government is entitled to have a person there. The question is the government entitled to have more than one person there? I think the answer is there are circumstances where you can make a showing that you need to have the person there, particularly if it's a technical matter. But that's going to be something we're going to have to decide, and so be prepared to present your arguments on there. Couple of things. Now here's another one, and this is a very much professional things. You are the lawyer, and you need to be the adult in the room. And if your client is misbehaving, it is not in your interest or your client's interest for that conduct to continue. And I've had some really bad situations where lawyers, one of the things that we were talking about the Murdaugh case, and I haven't watched it, but I'm curious about, what is it? You can't put your client on the stand if you think they're lying or if you know they're lying, and if you know your client is not being straightforward, that's not something you can permit. I mean, this is our hearings, you're under oath, and it's a crime. So you need to make sure that your client is behaving themselves. I don't have equitable jurisdiction. I can't, if somebody is misbehaving, I can't issue an injunction, and if they disobey, lock them up. I wish I could. And there've been a couple of times I'd like to have done that. I can't fine them. I can pop $500 or $1,000 per offense. And I've done that a couple of times. But don't let your client, and the clients usually are their own worst enemy. And you've probably had that experience, They really, really, really need to make sure that the client does not get out of control. Same thing for your witnesses. Make sure that you got them under control. I'm almost out of time. So I want to, let me mention, I said a little bit about this, but in the tax tribunal and OSA are very different in this regard. And that's the issue of summary determination or summary judgment. The tax tribunal summary judgment should be, in my opinion, should be the rule, not the exception. In OSA, administrative litigation, it is the reverse. And the reason it's the reverse goes back to the difference on discovery. In the tax tribunal, the CPA is available. There's no excuse for you not getting the facts in advance of the hearing. OSA is cowboy court, literally. I mean, we show up, and I go down to Greene County and they show up, and I literally pull up I open the file in the computer and there's usually nothing there. And they start telling me what happened. And I get, I get that where this is I keep coming back to these DOE cases because there's such time. I mean, they just suck up huge amounts of time because they're, oh my God, the detail. But we regularly get motions for summary determination filed by the school district. And they'll say, these facts aren't disputed, we win. Well, the law is very clear that unless there is absolutely no material fact that's not in dispute, we have to have a hearing. And because we are the fact gatherer, it is very clear that our job is to get the record developed. And I've educated the lawyers who appear in front of me, and I say, and I normally, and especially, what is it, Judge Malley, he says, the nicer I am to you, the more trouble you're in. And when I am being nice, it's usually because I want a good record, because I don't want this case to get appealed and get sent back and stuck in my lap again. I want the reviewing court to have a full record. And so I will almost never grant a motion for summary determination. I mean, and the case law is you should almost never grant a motion for summary determination in an administrative hearing, because again, the whole purpose of the hearing is it's cowboy court and your opportunity to lay out the facts of the day. So that was a little bit disjointed, but it's been 3 years since I've gotten to give this, David. So it's good to be here. Anything before we stop at 5, right?
We can stop whenever you want to stop.
Well, but I just want any questions or anything out there. It's good to see. I hope the virtual people are all enjoying their Facebook.
Virtual experience.
They're on virtual experience, looking at Facebook or reading their news. They're doom scrolling on Apple feed. It's like. So anyway, any questions or anything? Well, it's great.
Thank you.
Great to see y'all. Thank you.
Have a drink and a little something to eat.
Huh?